Welcome to On the Chain. This is Jeff here with co-host Chip. There's Chip, and we have two outstanding guests with us tonight. We've got under Chip, we've got Jeremy Hogan, attorney at law, and we've got the man, the myth, the legend, John Deaton. You guys know John taking on the SEC on behalf of the XRP community. Welcome, both of you guys. You guys are awesome.
Yeah, welcome, guys.
Listen, guys, I got to start off. I don't mean to be rude, but I thought this was going to be BitBoy and Deaton, not Hogan.
No, man.
Oh,
Again.
BitBoy?
Again.
yeah.
I mean, listen, at least
Wait a minute. Who's
with
BitBoy?
At least with BitBoy, I'm going to win either in the better legal acumen or better looking department. With this guy, I lose in both categories.
Oh my gosh!
You see how he's able to work in? You cut you down, then build you back up.
Nice.
Very
Well
simple.
done.
A vote for best dressed.
We're gonna have a lot of back and forth attorneying going on here tonight. Well, Jeff really wanted to name this one. He goes, "Hey, what do you think about this title? 2 attorneys, 3 opinions." I'm like, let's not go with that. I'm like, it's a little weird, you know.
I like that.
So let's just chill on that one. Well, guys, let's get ready. Let's go into it. We got a lot of questions tonight, and we have John and Jeremy. Let's do it. Bye-bye.
Let's go.
Welcome to On the Chain.
And we're back.
We are back.
Before we get going, guys, I want to just say, if you're new here, please like, subscribe, click that notification bell. I know you get tired of hearing it, but it really does help the channel, or you share it with people. That's the best way you can help. And before we get started, I want to give a big monstrous shout out to XRP Twin at XRP Twin. You know him better as Ferdy. He's an OG in the XRP space, but he was relentless, and he really wanted to see both of you on here. And I think he bugged that crap out of you for like a long time. And you know what? He got it done. And a big shout out to his brother who's watching too. I heard he might drop in. So that was, I want to just give that big shout out because Jeff and I really appreciate it, Ferdy.
Yeah. So, all right. We're waiting for a comment back from Ferdy.
There's one question Ferdy had to know. It's a burning question. He had to know. He's like, Deaton and Hogan, I got to know. Star Wars or Star Trek?
Star Wars, baby. Star Wars.
Boom.
James T. Kirk, brother. James
I knew that. We're off to a great start right there. Well, I did work with Mark Hamill for 5 years doing a .com show back in the early 90s. So I had to go with, even though I love Star Trek, I got to go with Star Wars. Jeff, what do you got?
You know what? Star Trek.
Look at this. What an even split we got going on tonight.
The only thing is, if you like Star Wars, you just have to disclaim the middle movies. He's like, okay, I'm the middle, I'm the beginning and then the end, and I just kind of disclaim the middle part of everything that happened there.
Yeah, George Lucas will want to
the original 3.
Yes, I'm the original 3 Star Wars. Yeah,
same here. The other one's got too outlandish, too much CGI, too craziness. But we're not here to talk about Star Wars. What we're here to talk about is a little bit of. Is the SEC nuts? Is XRP a security? We're going to get into some of that. I had a quick question from someone named Bond Crypt, a buddy of mine. He says, if I recall correctly, Jeremy, in one of your videos months ago, you mentioned some kind of a maximum date a lawsuit had to be over. Was it January 2022? Is there somewhere a final decision has to be taken?
Right. So every case in federal court, they do it the correct way, really. They start at the end and they work their way back. So in federal court, you have a trial date. That is the end of your case, unless there's an appeal, but that gets a little bit too technical. So we start at the trial date and we work our way back. And so we do have a trial date. I don't know off the top of my head when it is. I don't know if John knows off the top of his head, but I believe it's in May, June of next year.
Okay.
Yeah.
So it will end in 2022, more than likely, or possibly before.
Right.
Gotcha.
Yeah. Hey, a great place to start out. We have a lot of other questions, and I see here we have a question that came up from David Zalazar, and I think this is probably a really good place to start. We don't have to get extended into this, but more of an in-depth interpretation of the Howey test. And there's another one. Was that the Reeves test? Is that correct?
Is that the note, the test for notes?
The Reeves test is the promissory note type test, which, to be honest with you, I'm not familiar enough to really discuss. Obviously, Howie I can discuss, but I'd have to read up a lot more on Reeves or whatever it's called.
Yeah.
Yeah, but to start with the Howey test, I think one of the things that we hear from Gary Gensler a lot is that he only references one component of the Howey test, and it always has to do with earning off of other people's efforts. But there's 4 primary components of the Howey test, and he seems to ignore 3 of them. What are your guys' thoughts? As we dig into it, what's the importance of adhering to all 4 elements of the Howey test to be considered a security?
Well, you have to have all 4 factors, right? You have to have an investment in a common enterprise with the expectation of profit, where you're relying on the efforts of others. Right? That's the seminal 4-factor test. But if you get 3, if you get 3.5, right? If you get almost 4, no, it's got to be all 4 in order for it to be an investment contract, aka a security. The thing that disappoints me while we're talking about it, I'm just amazed. Gary Gensler's asked, is Bitcoin or Ethereum, is that a security? And there's a simple, absolute correct answer that any asset can be schemed, marketed, packaged into an investment contract with a company. But the asset itself, the underlying asset, is not a security. So Bitcoin in and of itself is not a security. XRP in and of itself, despite the SEC's allegations, is not a security. And neither is Ethereum. The question is, when a company has marketed, sold it, packaged it, have they done so and schemed it in a way that it constitutes it? And Hester Peirce, in her first interview with Tony, literally said she's trying to get the SEC away from thinking about the underlying asset as the security. And to me, it's ridiculous, because that would be saying that the oranges were the securities, right? Or that the orange groves themselves were security. So I just don't understand why he avoids that kind of response, because I don't think he wants to utter the words Bitcoin, Ethereum, or any asset isn't a security, because it limits his optionality, if you will.
And Jeremy,
yeah, I'm sorry. I was acting like the question was coming from a judge, and I was in the hearing not knowing what the hell the Reeves test was all about. So I did exactly what I did in court last week. I pulled out my phone and I was down here figuring it out. You guys were were talking. It's a skill that every young lawyer must learn. It's called the phone in front of the judge research skill. So apparently, the Reeves test is basically starts from the presumption that the note is a security. So if the note meets the 4 prongs of the Howey test, which John just talked about, it's a security. The Reeves test is kind of an exception to that rule, which says that if the note bears a family resemblance, that's a word that lawyers are going to love because it has no meaning whatsoever. But basically, the Reeves test lays out various types of notes, and if your security note resembles one of those notes, it's not a security. So basically, it's an exception to the Howey test. And it looks like stuff like a note secured by a mortgage. That's not a security. A short-term note of less than 9 months. That's not a security. I saw on Twitter that was kind of coming up today, and I just didn't have time to look into it today. So that's what the Reeves test is all about. I think there's some argument going on in Twitter on Twitter that that XRP might fall under that Reeves test exception. And I just haven't looked into it, but that's what we're looking at, whether XRP is going to fall under a family resemblance to one of these enumerated note situations.
great. Well, it's thanks for doing that on the spot. I mean, that's some pretty solid phone work right there, man. It's if you were in front of the judge. So we had some questions too, some other ones, but I want to throw some quick things up here. We had XRP Hollywood. All you gentlemen are looking dapper, which is always great. I think I'd take that. Thank you very much, XRP Hollywood. And then we had another one here. I want to see if there's another one here. Just
There's
had
a really good one here, Chip. From
where is Rough Rican? Where was it? There was another one. The thing is, they're going by so fast.
Here's a really
There we
good one
go.
here from JB Heavy Equipment. And he said, "Thank you guys. And Deaton sent you an email about my company accepting XRP as a payment because we offer a service. So when shady people decide to cancel their payment, it's a pain to go through the lien process. We eliminate by accepting a trustless settlement payment." And there you go, real time.
Absolutely, and that's one of the things, in the judge's decision. And when we get into it, I've read it obviously a couple times, and I'm more and more impressed by these two female judges. It doesn't matter they're female, but these two judges.
Right.
Every time I read a ruling, they're very meticulous. And so, for example, Judge Torres stated basically in denying the defendant part of the intervention, she basically said that, Ripple can make the case about the most important issue to us, which is today's XRP.
Mm-hmm.
Is present day XRP a security or not? And so the fact that she gets it right, and then when you look at the other language she used, it's very promising. That at least, I know there's a lot of conspiracy theorists out there that every time a Judge Netburn or someone doesn't rule in Ripple's favor, that all of a sudden they're on the take or anything. I have a lot of confidence. I may end up disagreeing with some of the rulings, but I have a lot of confidence in these two judges, to be honest with you.
Yeah, same for you, Jeremy?
Yeah, I think the one thing you definitely cannot say is that either judge is come down on the SEC's favor. I mean, if anything, you'd be looking at the rulings we've had so far and say that there might be even a little bit of a leaning towards Ripple's side of things. So you could say a lot of things about the judges, but that's not one. I'm also just really sorry, Chip. I'm almost just really surprised how fast they've caught on to this. For most attorneys I know and most judges, the idea of crypto and blockchain, all they know is Bitcoin and something about maybe using it for illegal purposes. I mean, that's really what they know when they hear crypto. And you could just almost see Judge Netburn catching on as things are moving along here, and really fast. I mean, within a month or two, I think that first hearing, she was a little off. I think she asked some questions that kind of showed that she wasn't really understanding the issues. But by that second hearing in April, she was spot on.
And also say the clarification she asked for, like the questions were solid, right? As it started, proceeding, what she was asking, and then she wasn't letting him off the hook because they're supposed to turn over some stuff, and she's like, she would say it really kindly, like, "Now, I just want to let you know, you guys are going to turn over those documents, okay?" And then like the next hearing, it's like, just a reminder to turn over those documents. It's like I think she's asked maybe 2 or 3 times. What's going on with that? I want to ask both of you. We'll start with Jeremy, but Jeremy, what's going on with the fact that some of the things that the judge has already said, look, you need to turn them over, and there seems to be a little bit of resistance there.
Well, there obviously was a lot of resistance on the SEC's part, and I think we're seeing some resistance now on these videotaped meetings from Ripple as well. Obviously, in any discovery battle, there's things you don't want to give the other side. So they're both trying to hide stuff from each other, and that's just the nature of the beast. If you could get through discovery and not give one single document to the other side, you would. I mean, it's war. It literally is war. Litigation is war, and you can't give anything to the other side. So you're seeing they would hide whatever they could from the other side if the judge will let them. And I think what you're seeing now, I think Judge Netburn has been more than courteous but I think John's going to agree with you. And I don't know if it's because there's so many people watching this or listening, or maybe this is just the nature of what kind of judge she is. But I know very few judges that I'm ever in front of that would have been as patient as she has been. So that's been a little surprising to me. But at the end of the day, she did ask for the documents. She's doing an in-camera review. And so that's what we wanted to see. It's just, I was surprised that it took this long to get there.
Yeah, I think, it's a step-by-step process. So she orders them to produce. First, she says they're relevant and you have to produce the documents. Then they have an issue on the clarification, and she rules the second time you got to produce the documents and then produce a privilege log. So they're claiming each and every document, of course, is privileged. And then she has to decide, one, whether that's true. And then B, even if there is a privilege, should she override that privilege because there's no way for Ripple to otherwise gain access to that type of evidence. So we'll see. When everyone talks about settlement, again, until the SEC is faced with some rulings. Now, one, the SEC knows that amicus has been granted, so they have to deal with XRP holders coming in. That's something they have to worry about that they didn't have to worry about before, right?
Right.
If she orders these documents, for example, as Jeremy highlighted in one of his videos or in his tweets, that memo that was disseminated the day before the Hinman speech, right, on June 13th, 2018, the legal analysis of XRP, which we have to assume, basically said, well, it's a gray area. That's my assumption, that it may fail on one of the prongs. There could be some legal analysis that basically says we're going to have a hard time proving that it's a security or something like that, and that's why they don't want to turn it over. But if that gets ruled to turn over, now when there's a ruling on the fair notice, the motion to strike the fair notice, when we get that ruling, a motion to dismiss the defendants, right, the particular defendants, we got to hear that. At some point, the SEC may be faced with, we may very well lose this case, and losing it to the fair notice defense is going to put us out of the business. The one thing that Gary Gensler does not want to lose is this ability of what we call the land grab, right? This jurisdictional grab. I want cryptocurrency under the SEC because I'm with the SEC. That's what he wants. And when he's faced with a possibility that could be over, then maybe the SEC will come to the table. And the reason why it was so important for, in my opinion, for XRP holders to at least have a voice is, I'll tell you what my biggest fear is, and I'd like to hear what Jeremy thinks about it, if he thinks that, there's no chance of this. What I fear is that if the SEC has to turn over the documents, they have to deal with XRP holders. Maybe the fair notice defense, they lose on the motion to strike. Do they just move to dismiss the case? Now, to me, that is the danger, because what's Ripple going to do? Say, well, we want our attorney's fees. But if they were to dismiss the case, and maybe they get it, all right, here's $10 million. But if they dismiss the case, then we're back as though it never happened. And that doesn't mean Coinbase relist XRP the next day.
Right.
Right. And so to me, that's the biggest fear. Whereas if that happened, at least we'd be seeking declaratory judgment that today's XRP is not a security or something. Whether the court would allow it, I don't know. But at least we're in there trying to prevent that uncertainty from continuing. But to me, that's my biggest fear, that I lose sleep.
That's great. But Jeremy, before you answer that, I want to add another element to what John was saying. And this is something that, John, you're bringing up the fact, bringing the voice of the XRP community, bringing the voice of the retail investor, bringing the voice of those that are actually building in the space outside of Ripple. I think that's really significant. Now, here's the element to add to all this. And we've seen this twice now. We saw it with the infrastructure bill, where I think they never expected the level of feedback and anger that they would get from the crypto community, ringing the senators' phones off the hook. That was on the infrastructure bill. The crypto community rose up and said, hey, you know what? We don't agree with you putting the crypto bill and shove it somewhere in the back pages of this infrastructure bill that's not relevant. But we're seeing the exact same thing with this SEC v. Ripple case, where you have the Ripple, you have the XRP community at large and crypto communities coming to the table and saying, hey, SEC, you supposedly are there to support the retail investor, but you're not supporting us. We've now lost billions of dollars because of this action that you've taken against Ripple. But yet now every time they have a hearing, there's thousands of people that are trying to dial in and listen. To me, that seems to be a little bit unprecedented, that the retail investors are coming at the defense of the company that the SEC is taking action against.
Yeah, it really is unprecedented. And in case authority, it's unprecedented as well. We just saw in the judge's order on John's motion, she basically said there's no case authority for investors in a security to want to intervene in a lawsuit almost against themselves in essence. This has never been done before, or at least there's no case authority that shows her what to do about it. So she had to pull from other cases that were kind of semi-related. So it really is unprecedented. I can't tell you guys enough how important this is, what John's doing, or the movement that he started. Because, you know, you always have to remember that judges are just people. And I've known a guy that he was a guy, he was my friend, drank beer, regular guy. He became a lawyer, and now he's a judge. Judges are just people. And if they know that what the SEC doing is opposed by the very people that they're supposed to be protecting, that makes a humongous difference. Absolutely makes a humongous difference. I can't even tell you how much of a difference that makes. So, you know, kudos to John for sticking his neck in there. He's got the hard job. I've got the easy job. I just report on it. He's got to actually do the work. So I feel for him.
I thought you were writing a brief, brother. Come on. Well, you know what? We're gonna get your wife to do the work. She's probably smarter than both of us.
You got to put him to work, but he breaks it down so eloquently and with the sense of humor in there as well, you know. And hey, I want to just say while you guys were talking, John, you're delivering that very well. Now, what you guys might not know is that Jeff and I have a bet with Mr. B and Coining 203, better known as Alex. So while you're saying that, boom, it flashes up the text on my screen, and that's when we win the bet, because their bet is, and it's a steakhouse up in, you know, either Orlando or it's going to be down here in South Florida, and the bet is, we're like, they're not going to settle. It's not going to be a settlement. And they're like, it's going to settle. So if it settles, Jeff and I are probably heading to Orlando. I'll bring you along too, Jeremy, if you're open, but come on, hang out with us. We're going to pay for a steak dinner. Now, if it's the other way, it's going to be a journey down south. Mr. B and Coining, but man, the timing of that, he goes, and that's when we win the bet. I don't know, man.
I don't mean to throw a little wrinkle in your bet, but this case very well, parts of it may settle, parts of it may continue to trial. These cases can be pieced up in a lot of different ways, and I don't think people understand that this is not an all or nothing situation.
How do we deal with that?
Yeah, now you're gonna have to think how you're gonna.
They buy us dinner, we buy them dinner.
Yeah, we go have fun.
We just
meet halfway. That sounds
Right,
fair.
exactly.
The piece that John is involved with, which is the current sales of XRP holders, could very well be the first piece that goes at summary judgment. That piece could go at summary judgment, or it could be settled out, and they could just move forward on damages as to sales from a certain period of time backwards, go to trial on that issue, and then Ripple could lose on sales from 2013. I mean, the case could kind of be pieced out like that. Anything's kind of possible when you're in litigation.
But do you guys see, and do you see that there's a possibility? Because John, you've expressed your worst fear, right? But do you see a scenario where potentially there is something? Because one of the things they didn't do is they could have come out and say, well, you know, we're not arguing today's XRP. I mean, Hinman was very gratuitous in his personal opinions at the Yahoo, you know, that when he gave that speech, right? But is there a possibility where there might be some kind of clarity? What would provide that sort of clarity? And we'll start first with Jeremy. Jeremy, what do you think about that? Is there a potential possibility? Because if all this does that, and it's piecemeal, like you say, where's going to be like, well, we're pretty sure, are we still worried about today's XRP with the use cases and people like, you know, James Rule XRP getting paid in XRP? Then we just had, you know, the previous gentleman who can get paid in XRP.
Right. So I think that clarity comes from a ruling or a settlement that makes clear what the status of current sales of XRP is. That's clarity, because that means that the XRP that you hold, the XRP that I hold, the XRP that John's clients hold are not securities. And that's what's needed to move forward. Everything else is just about money. Everything that's not about current sales is just money. And so that isn't going to bring clarity to anyone. So it's really the issue that John is dealing with, which is the important one.
Yeah, you know, obviously, I've always been a little surprised at the SEC's approach, you know, and I'm just being objective here. I'm not being overly critical, because I don't understand why they wouldn't just go with, you know, from 2013 to 2017, the ecosystem was very different than it is today. You had, you know, even a higher percentage of the XRP than you do today. And these particular sales during these particular transactions, those constitute unregistered security. But the transfer of XRP in the secondary market, of course, unaffiliated with Ripple, that's not a security. I've always struggled with why they have not made that clear, right? And if you look at their opposition to the motion to intervene, on the same page, on page 24, in one sentence it says, the movements, that's XRP holders, are claiming that we're alleging that XRP is a security per se. That's not the case. They write that. And then 4 sentences down, they say, quote, the XRP today, including XRP sold in the secondary market, represents an investment contract with Ripple. Like, and so in the very same page, I don't believe they've reconciled their own theory. And I think it goes to what Jeremy said when he's like, okay, there's 1,700 cells, and you're taking the position that that's almost easier for them, right? To just say, well, everything is an XRP, everything is a security. And they've almost adopted that approach, and they back themselves in a corner. And so it's clear that as Brian Brooks has said, it's ripe for a settlement. Pay $50 million, right? Give them a victory. The SEC can say, we still won. We got $50 million. Hell, make it $100 million, right?
Easy, John. Let's take it easy. Let's not go crazy now.
What I'm just saying is that they get their pound of flesh. They get their victory publicly. And they say that these sales during these years were unregistered securities. And there's a declaration that ongoing sales will not be viewed as a security because basically, we go back to the Hidden speech, it's sufficiently decentralized. There's a lot of users on the ledger now, et cetera, et cetera. That's clearly what should happen, to be honest with you. But when Gary Gensler was at MIT and he was saying, oh, this is going to be resolved by the courts, I think they actually thought that. I think the SEC came into this believing that this case was going to be a ruling on summary judgment, and they did not anticipate. I think they underestimated the fair notice defense. I think they overestimated their abilities, if you will, or the strengths of their case. And it's only going to be when they're faced with the reality of, if we lose this case to fair notice defense, we're not going to have a case against any other cryptocurrency that has existed for the last 8 years, 10 years, right? They're only going to then be ICOs, initial coin offerings, things of that nature going forward. And I think until we get to that point, that's when the SEC, I think, will take it serious. Now, the question is, what if they say to Ripple, pay $25 million fine and we'll settle the case? And they're not willing to say that ongoing sales by Ripple or the secondary market are not securities.
And it doesn't seem, John, it seems like from everything that we've heard from Stuart Alderati and from Brad Garlinghouse and the team over at Ripple, that there won't be a settlement like that. They're looking for the long game, which is full clarity. And then it seems like, the way we hear from Gary Gensler, and now when we saw him in hearing with senators questioning him, and he just doesn't seem willing to bend in any way, shape, or form. Everything that he says about the crypto space being a security is based on his own belief, his own opinion. And it's not based, he doesn't bring up fact. Just like when he told Brian Armstrong over at Coinbase, hey, next week, if you guys roll out your product, we're suing you. Well, why? Well, it's a security. Well, why is it a security? Well, we're going to sue you. We're not going to tell you why. And that seems to be his persona. And he danced around all of the questioning from McHenry, from Davidson, from Emmer, and they were hammering him left and right. And he always falls back on the fact that he taught at MIT and he knows what he's doing, and it's a security, and that's it. And so how do you reconcile that part of it? How do you get the case? And obviously he wants to stand his ground, but it just doesn't seem like his mentality, like he even cares. Like he's going to drive this case until they lose. Do you think that there's something there with his personality that wouldn't even be willing to make a change?
Well, we haven't seen how strong Gensler's convictions are and his new director of enforcement. But what I can tell you is this. In any case, when you walk into mediation, and John knows this, I was in mediation last week. My client literally was here and the insurance company was over here. This case was never going to settle. Never going to settle. My client wanted $1 million. The insurance company thought that they didn't have to pay anything. You would have walked in there, you would have said, this is just a waste of time. 3 hours later, that case was settled. Both parties walked in there saying the exact same things. And you'll see this in mediation time after time after time. Both parties walk into a mediation saying, we want this, that's it. We won't take anything less. And 3 hours later, the case is resolved and done. So I don't put too much money on what people say in litigation, because you have to be a badass. You have to walk in there and say, I'm not settling. I'm going to kick your ass at trial. I'll see you at summary judgment. You've got to say that. Otherwise, you're never going to get the best deal you can.
Right. And that's why Gensler sticks to the script, because if he goes off the script, like the other day when he's asked, what about Bitcoin? What about ETH? You know, what is it? He goes, I'm not going to get into any particular one. Well, how about the two biggest ones that everyone's familiar with? Can you just give us, because if you're going to tell us most of crypto, their securities, can you just maybe comment on Bitcoin and maybe Ethereum to see, like, are they or are they not? You know, and one of the things that came up, I know Charles Gasparino tweeted this out, and he said that they had spoken to somebody over the SEC enforcement, at least I think that was the tweet or whatever. And he said, you know, one of the things that they told him was the reason that the SEC even approached Ripple on this was because their network wasn't built out. And I don't know if you guys remember seeing that tweet. And I'm thinking to myself, well, you know, what about the Ethereum? By the way, when's Ethereum 2.0 coming out? I've been promised it for like 2.5 years now. Apparently their network's still not complete, and apparently that wasn't sort of a roundabout ICO. That was an initial coin, wasn't an ICO per se, but 2004 they launched it. The coins rolled around in 2000, or 15 rather, 2014, 2015. Do you guys is that like a real? I mean, is that something that you would really say that the network wasn't built out? Because Ripple's network's never going to be built out, right? They're always laying down rails. They're always putting in. They're a software company. Now, you know, when certain news comes out, this is the part that kills me. It's like almost like bad news sort of sinks Ripple, XRP a little bit. You know, something comes out, Ripple just signed a new partner. Nothing happens to XRP. So I'm kind of waiting for where's that effort of others. That effort of others isn't really paying off dividends as far as the price is concerned, because they don't really have any correlation. The best news of all can happen. The reason we went up to 384, in that 2018 run up was because someone thought the Coinbase was going to list it. And then when they finally did, everyone's like, hold my beer. Nobody cared. Is that a defense? I mean, did you guys hear that at all in that Gasparino tweet that he claimed that they talked to them about that? The network?
Yeah, I mean, I Charlie and I talked about it, and listen, it's just another time. The SEC is very transactional. They say whatever they can in the moment. They do it with Judge Netburn. They do it with the press. They're pressed for this. Why did Ether get a pass versus XRP? They held an ICO, and so Ripple's still building, and that's why. I mean, they're just intellectually dishonest, because what they need to just come out and say, because it's the truth, is that Ripple owns 55% of the asset. And they believe that ownership of 55% of the asset somehow transforms it into a security because of that fact. But there's no fifth prong of the Howey test that says how much of the asset does a particular entity own. So they can't fit it. So that's why they're going with the everything in the world is a security in the XRP ecosystem, despite the fact that this case was investigated for 30 months. It was rushed, and they're paying the price for rush. When you file it on your last day and you throw the two executives on the complaint, even though you're elevating your standard of proof, you're doing it for the wrong reasons. And that's what's coming to bite them in the ass. And that's a fact, right? Because Jay Clayton, he publicly said, to Grunfest, at that ABA hearing or meeting, he says, I like to add the executives. And Grunfest says, not in a non-fraud case. And he goes, no, even then, because it changes the dynamic of the case. And Grunfest says, yeah, but you elevate the burden of proof. But it was a rush job. let's file this case as I'm walking out the door. And it wasn't thought out. It wasn't planned. And because it wasn't planned, look at the fact, people are surprised. Some of the experts, so-called experts, are surprised we were granted amicus. But if you read the complaint, 20% of it talks about XRP holders. If you go, and I've done it paragraph through paragraph, and I did the math, and they come out and they say no XRP holders use it for any use cases. They say that XRP users cannot develop the ecosystem. They don't have the requisite expertise or technical knowledge. They just flat out come out with this crazy theory that 7.5 years retroactively we're going to declare XRP a security, because I think the motive behind the lawsuit was bad motive. Right? It wasn't for let's protect disclosures, let's protect and safeguard, our securities laws. If it was, it wouldn't have been done the way it was. It wouldn't have been filed the way it was.
Yeah. Okay, so just to take a little step into this, kind of like a what if. So you're going through this, and Notorious XRP is asking, if the case is dismissed because of these different eventualities that could come up, does that bring about clarity? And I believe you referenced it before, but it just seems if it's dismissed, we're kind of back to square one and there's nothing. Is that Jeremy, start with you?
First, let me throw out that I love that guy's name, Notorious XRP, Notorious BIG. You're right there with me, and I love that. So the short answer is no, a dismissal. So I don't know if people know in general, but the plaintiff in a case, which is the SEC in this case, can dismiss a lawsuit once and refile it. If you dismiss it twice, it's considered with prejudice and you can't refile it. So the problem that John has in his worst case scenario is a good fear to have, because the SEC can dismiss this lawsuit and next year refile it again. So it doesn't bring any clarity to anyone. There is some clarity in a dismissal because it would be a defeat to the SEC. And that's going to embolden other cryptocurrencies, or that's going to embolden the defendant's position, but it's not going to bring any clarity. So I think that is a definite no clarity there.
Got it.
I was trying to think of a Notorious B.I.G. song to throw in there, but I couldn't think of one.
Well, I always think of Notorious by Duran Duran. Notorious. That's the one that always comes to mind.
Yeah.
John, did you want to comment on that?
No, I just agree with Jeremy. I was hypnotized.
Oh, what happens, man? I mean, eloquence.
There's your reference to BIG.
There you go. So I wanted to just say, take a little moment here, guys. If you're first time here, please like, subscribe, click that notification bell, and that way you're notified anytime we go live. By the way, we stream 5 days, well, 6 days. Jeff does his rants on Saturday morning, so let's say 6 days. Monday or Sunday through Thursday, 8 p.m. till 9 p.m. every single night. When we usually end up talking about is Daddy G Gensler, because he's everyone's daddy, interjecting his personal opinions, and we also break down the news of the day, a lot of different projects, and well, I gotta be careful. I can't say projects anymore. So anyway, just give us a like and a subscribe. But anyway.
Hey, and to that point, actually, there are a couple of good questions here. One from Oscar Marson, and he was saying, I have a question for both of you. When doing public appearances like this one, are you ever afraid you might say something that could be used against you or ripple in court, especially now that the SEC seems somewhat desperate and surely keeping a watch on anything that might help their case? I've heard Gary downvotes on the chain every night, but he's still a huge fan. Thanks.
I have a lot of worries in my life. That is definitely not one.
And these are OGs, man. They're pros. Come on, John. I don't think you've ever been nervous. All right, former Marine. I mean, federal prosecutor.
What's the SEC attorneys going to do? Say I promote violence and drug use? Oh, they already said.
Oh, that's already came out and said that. But John, I'm going to say something. You sent us an email predicting that all that would happen. Chip Jeff, here's my list of predictions, all spot on, by the way. And it was cool that you did that because we've got the date of the email, and you were. They were basically going to rake you over the coals with all. I mean,
unbelievable.
They went a little bit too crazy, though.
I sent you guys that email. I also sent Moon Lambo a similar email. And then I think it was like 4:10. I just posted a tweet that said date stamp tweet prediction. If you can't attack the message, you will attack the messenger. I mean, I expected it. And a lot of it was, when you're I've been a federal prosecutor. I've dealt with prosecutors. They're used to winning, right? And they're used to, and the SEC's used to winning, and most companies can't afford the former SEC chairwoman. They can't afford the former director of enforcement. They can't afford the former director of corporation and finance. I mean, all of those people have been on Ripple's team. And so you combine that with these rulings that are not going in their favor, and it really gets under the skin of career prosecutors. And so I just knew that, and plus, listen, I'm not one of these $1,500 an hour white shoe lawyers who went to Princeton and then went to Yale. And so I come from a different kind of environment. And so, quite frankly, a lot of them don't have a sense of humor. So, I mean, look at the fact that I make a video and I interject my cousin Vinny excerpts into the video, and where the judge goes, "You on drugs?" And then they say I'm promoting drug use, right? And so it's just, but I think that shows you that that's a level of fear, that they don't have faith in what they're doing. When you don't have faith in what you're doing and confidence in what you're doing, it creates an insecurity, and then you're a lot of times you attack the other side in ways that have nothing to do with the underlying issues in the case. So. But at this point, no, I'm not worried about anything. Obviously, I'm not gonna say anything prejudicial, to XRP holders.
Yeah,
Outstanding. Yeah. Here's another one from Mel G. Now that we're all in this case, will you know before the public if there is a settlement? And then she says, "Blessing to all, good always wins. P.S. This was paid for with XRP."
Thank you.
Not necessarily. I mean, one thing that listen, and I can tell you, there's already some things in the works. But one of the reasons when the judge said that, Ripple could she actually said that, because one of the reasons I said that we should be in the case as parties is because we have evidence that Ripple doesn't. Ripple deferred to my letter where I cite the use cases for XRP in their answers to interrogatories, where they were asked, list all the use cases of XRP. And they said, we use it for cross-border payments and remittances. See Deaton's letter where he cites other people using it independent of us. And the judge's answer was, well, you can depose these XRP holders and you can get to that evidence. So.
Yeah, very sweet. I want to throw this up here too. Jackie says, "Thank you, John and Jeremy." Hang on a second. We lost John. Man. As always, Chip and Jeff, case will go down in history books. Yeah, it really will be one for the ages. I want to ask you about that, Jeremy. So one of the first, I think, inklings that we got, the magnitude as far as the judge was concerned, in one of the early hearings, we went from having, I don't know, maybe a couple hundred people available to be on the hearing, to the next time it was 4,000, and that capped out. I think that's where it's sort of the magnitude of this really rose. Do you think that maybe the judge or everybody was really like, wow, this is a lot bigger focus? And it is really, if last century we had the Howey test in the late 40s, that sort of, the courts decided those, created those 4 prongs that we're still living with today. Mm-hmm. Do you think that they started getting wind of this is the case of the century, especially when it comes to the SEC and creating precedents?
I think there was 2 things going on there. I think that initially there was a lot of gloom and doom out there. When I started paying attention to the Ripple lawsuit, it was early January. And if you remember back then, Ripple got sued, XRP is going to go to zero, Ripple's going to be out of business. This is horrible. And I think that was the mindset. It was almost like someone got charged with a crime and he was going to be going to prison and there was nothing anyone could do about it. And I think that was the mindset for the first couple of months. I think what you're seeing is that people started to it was almost like a Rocky moment where Ripple, like, I don't know, you were on the ground and got kind of punched and they were knocked down, but Ripple put up the finger in the air. That was Hulk Hogan, but and I think people started to believe. I think people started to believe that they could win, and once that got out, I think people started to jump on the bandwagon. They're like, look, Ripple can win this. Rocky can beat up the Russian guy. I forget, it was Rocky 3. So I think that was one part of it, and the second part, I think word got out that that this was an important case for the whole industry. And especially, there wasn't much regulation. It was kind of slow. There were smaller lawsuits that were filed against smaller companies. This was really the first big lawsuit against a big player. And so this is a super important case. And I think so, one, you had people that started to believe, and two, people started to realize how important this was. And now you see, 4,000 people on every hearing.
Exactly. John, did you want to answer, the importance of this case as far as like a landmark type of a case of the century?
Yeah, I think that, I personally was disappointed in the Digital Chamber of Commerce. I was disappointed in the exchanges. I feel strongly, and I probably would have, if I were the general counsel of Coinbase, I probably wouldn't be very long, because, I would have said, listen, this is an attack on our industry. They're going to sue us for doing the same products that others are doing. I'm going to recommend you relist XRP, and then file a request to file an amicus brief on behalf of the exchanges who now have standing because they're selling XRP. And if this XRP is deemed a security, then that's going to affect their business. And so none of that's happened, obviously. But I think now, because of the belief that Gary Gensler was going to be crypto friendly, I think that it allowed for the other companies, it allowed for these people that maybe not be fans of Ripple to say, well, this is a Ripple issue only situation, right? And now when they see the writing on the wall and that Gary Gensler, if take away the Ripple case, and I bet a lot of people rather have Jay Clayton back. You know what I mean?
We're in your corner with that.
Yeah. You know what I mean? And so I think now that they see that he's coming after crypto, he's not even willing to say that Ethereum and Bitcoin are not securities, which his predecessors said repeatedly, right? He just won't say it. He won't commit to anything. And it's clear that he goes from MIT saying 75% of the market are commodities or currencies to now almost everything that's on the market is in fact a security. And I think that now they're getting sort of on the wagon. And listen, that's fine. I'll welcome them, because it's better late than never, right? I think that it's time to end, the shit coin arguments and all of that, and say, we live in the United States, and let the best tech win, let the best company win, let the best crypto win, and not let the government decide who's going to be the winners and the losers.
There you go. Well said. Really well said. So this came from Versed Toast. Is there a legal value in the fact that the XRP ledger is decentralized by validators? The community is its own SEC as they dictate the rules on the network. Could this set a decentralized standard? Who wants to take that one? Let's start with Jeremy.
Yeah, sure. So the decentralization of the network is a piece of the pie in the case. It definitely is. And that you've already seen, I think Mr. Gasparino was talking about earlier. One of his sources told him that that's how they're going to attack Ripple. So there is legal value in that it is decentralized. Obviously, the SEC is going to try to argue that it's not. And that will be what we call a battle of experts, meaning Ripple is going to hire an expert, and they already have. You might have already actually been deposed. I don't know. They're going to hire an expert who's going to talk to the judge about, in a deposition, through a deposition, we'll talk to the judge about how the XRP ledger is decentralized. And the SEC will hire an expert who will say the exact opposite. And then it's a matter of taking it in front of the judge, and the judge is going to listen to what, she's going to make a decision based upon what those experts say. So there is some legal value in the fact that the ledger is decentralized. And I'm not quite sure how the SEC is going to say it's not. So we shall see.
It'd be interesting.
Yeah.
John, thoughts?
Yeah, I think that, well, what's important is that, the Judge Netburn has ruled that the Bitcoin Ethereum documents are relevant as it applies to the court's application of the Howey factors. So I believe that the SEC is stuck with this decentralization construct of the Hinman speech, because I think that the goal for Ripple or XRP holders is to show that the XRP ledger is at least equal to or more decentralized than the Ethereum network. Because if we can show that, then we should win based on, the fair notice defense and all of that, because it meets that sort of decentralized construct. Now, I don't believe Gary Gensler and the SEC want any type of decentralization clear test, because then it's less vague than it is today, right? And I think that they want vagueness because it gives them their options. Gary Gensler is never going to do what Hester Peirce wants. He's never going to say these are securities and this list are non-securities. He's just not going to do it.
Nice. So Michael O'Hara has a question. If the SEC were to approve a Bitcoin ETF prior to a summary judgment, could that be helpful to Ripple for fair notice defense? Maybe not likely, but just curious.
I don't think so. I saw that there was some kind of Bitcoin ETF. The ETF didn't actually hold the Bitcoin directly, but indirectly they held it and they were approved. If it was Ethereum, I think we could make an argument that that would be helpful, but I don't think a Bitcoin ETF is going to help Ripple too much.
Gotcha.
I agree. I agree with Jeremy.
I concur. Wow, look at this agreement. I love it.
Pretty great. Huh. Hey, there were some really great questions that we had posted that came from earlier. I think we covered a lot of the topics. Jay V had put up a question talking about how much what is it, the how do you pronounce it, the amicus right, I'm trying to get the right the amicus. How much does that weigh in on the outcome of the case? I think you might have touched a little bit on that earlier.
I'll let Jeremy handle that because I'd like to hear a more objective point of view.
But let me ask John a question just that's kind of related to that. So John, is your understanding from the order, because I couldn't quite figure it out from the judge's order, that you're going to be allowed to present any separate evidence, or are you going to be limited to the evidence that is in the plaintiff and defendant briefs?
Well, she said that we're not going to be allowed to call witnesses. So the way I read it is that if you're talking about an actual trial, she's not going to let me to say, okay, I call James Rule XRP or I call Jay from Spin to Bits. But she has indicated that in her ruling that Ripple can do it through us. In other words, she's basically saying they can depose the people that I was going to offer, right? So, for example, Spin to Bits, that I would offer up and say, look, this proves certain things, right? It proves the utility of XRP ledger. It improves someone who had no knowledge to Ripple, had nothing to do with Ripple, didn't ask permission, went on there, developed his own system, and look, judge, that he can move, all this Bitcoin on the ledger, and they're claiming that the 3 million in Bitcoin isn't a security, but the 0.0005 XRP that was used to do it is. And so she basically said they can use those type of examples in their case. But I believe that I would be able to use evidence as far as an affidavits in a declaratory or summary judgment.
Okay. In that case, I think the amicus brief is going to be humongous. I mean, it's super important. It's great that it's in there, because the judge, if she did not grant that, and if John was not allowed to submit a brief, the judge can't refer to it on the record. So now she's going to be able to actually refer to his brief in her order. And, judges are always worried about supporting their orders. They're very cognizant of that. And this judge obviously looks like she's going to put together a very nice order, because on something like John's motion, she put together a very detailed order That took a lot of time to put together. So I'm really looking forward to her order on the summary judgment motions. But she's going to be able to refer to John's brief, and that's just humongous.
Nice. I appreciate that. Some good questions tonight from everybody. You got something, Jeff?
There's a whole bunch of them that have popped up, and we still have some others that came to us earlier. But this came from Alex D. Blogs. He's saying, are we just hoping that XRP is not a security so that we can make money? What if XRP is a security? This could be another 3 years, diversified security, XRP.
I don't give a
yeah.
what you do with your money.
Think about that part of it.
There's no way it's a security. Today's XRP is not a security. Would we all be in agreement on that?
Yeah, I mean, listen, let me ask you guys this question, all right? And this is an example that needs to get before the judge. Are you receiving XRP tonight?
Yes, we are. Actually, people that are watching it are donating it via Coil. And at the end of every broadcast, we get an email that says you guys earned this much XRP. And usually we'll get...
I put you on the spot because did you acquire tonight's XRP for investment purposes?
No.
No. You might use that to buy a new microphone for your podcast. You might use that to do something else for infrastructure as you build out. Maybe you're going to advertise, whatever. So there has to be a designation of not today's XRP. Again, many times content providers such as yourself acquire it for a non-investment use. And so I don't think there's ever going to be a declaration that XRP today is a security. It's going to have to be reaffirmed in the court's ruling that is it possible for a company, whether it's Ripple or the Deaton law firm, to use XRP as a security? Sure, it's possible. We can come up with a hypothetical, but that the token itself is not. And unfortunately, we're going to need that kind of like declaration because, as I said before, Hester Peirce says she's trying to get the SEC away from thinking about the token as the security.
That's a great point. Really good point. Hey, here's another one here. Joel, Jeremy and John, thank you so much for all the work you do. You're writing yourselves into the history books. You're both prolific already. Jeff and Chip, thanks for this platform. Outstanding. Here's another one from let's say Chingy Jade or 38. Can't see what that 3 there. But love and appreciate Deaton and Hogan for everything you guys have done. Several XRP set aside for you guys when we eventually win. There's just it's a lot of great ones that just came through. Here's one. If there were to be a Ripple test, what do you guys think the prongs would be in your opinion? That's a great question. I love that.
That's interesting.
Throwing that over to you, Jeremy. You start with that one.
Oh, wonderful. Okay, I get the hard one. Ripple test. Okay. So, the way that we would get a Ripple test, just to back up really fast, is Ripple or the SEC would win at summary judgment or at trial, and then someone would appeal that win, and then we would have an appellate court make a test based upon their ruling as to whether someone should or shouldn't have lost this case. So that's how that would all play out. And if someone appeals the appeal, that goes to the U.S. Supreme Court, and then you would have the Ripple test. Okay. I don't think that under current U.S. laws that the appellate court is going to be able to set up something where you have a test for cryptocurrencies and you have a test for other securities. It's just not in the law. That's not in the court's jurisdiction at this time. It's not in front of them. So what they would have to do is they would have to somehow carve out an exception for this specific set of circumstances. And I don't know what the set of circumstances, the Ripple test might be that if the SEC waits for 8 years before they file their lawsuit, that they're going to lose. That's too long. The Ripple test could be that if you have something that, and I like your argument, Chip, I really like this argument that the price of XRP does not follow anything that Ripple seems to do. It follows the price of Bitcoin and other cryptocurrencies. That could be the test. That would be the test for whether a crypto is a security or not. Does the thing that the underlying company do have any effect on the price of that thing? That's something that could come out of this case. And that's actually my favorite argument. It could be if you have a decentralized crypto or blockchain network, and it's decentralized to the extent that that the XRP ledger is, that is by definition, by law, not a security. So you can't really have Howey be overturned and have a complete Ripple test with prongs and all that kind of thing, because you're just going to have a kind of a more nuanced Ripple test, which is going to be, in this specific set of circumstances, this is not a security. That was an interesting question, but it made me think too hard.
Nice. It was a good one, right?
Really great one. John, what are your thoughts?
I agree with everything Jeremy said. The only way a Ripple test is developed is through Congress, and where Congress comes out and they use this case and they look at the technology itself, and then they come out and they say that a pure ICO falls under Howey, but once you reach this level of decentralization, and then they have specific factors, whether that means that you have to have less than 10% of the validators, or that you have to have a certain amount of this or amount of that, or it could even be, if it was going against Ripple, it could be that no one entity can have more than X percentage of the outstanding supply, right? But that's only going to come from Congress, because otherwise the Ripple test that people are thinking of through the court system is a decade from now. That's how long it would take to get to the Supreme Court and come down with a decision.
Nice. Well, we are running up of time, guys, and we really appreciate you guys coming on. We have one more question here.
And there were a couple referring to, how can people within the community support this effort, this initiative? Here's one here from Susie. Question for John: if we've signed the petition, does that make us part of the 19,000? I think now 22 or 23 XRP holders. Are you signed the petition? Are they now part of the case?
Yeah, if you look at the caption of the case for everybody, right? The caption of the judge's order, it lists the 6 individuals, and then it says, and all similarly situated XRP holders. That's in the case caption. And while I could take the opportunity, because there's a lot of people online saying, why would you give Deaton your holdings? There's none of that's required. If you go to the Google form, it's your name, your address, your email, your phone number, and whether you live in the United States or not is another question. And if you don't, then where do you live? And then there's a comment section that can be left blank. Some people say, I bought XRP on this day, or I own 10,000 or 1,200 or 2, whatever it is, which isn't required. And so if you sign onto that form, then yes, you will be a part of the entire XRP holders amicus. And right now I think we hit 33,000 an hour ago.
Yeah, by the way, if you go follow John, he tweeted out I love what you tweeted, John. It's like, it doesn't matter where you live. This is a global focus right now, because this affects everybody potentially, right? Obviously the United States, but guys, let's hit 40, let's hit 50, because that doesn't even come close to the XRP holders, but we're starting to get there.
Go ahead. Jeremy has made the point, on his channel and on his Twitter, where he's made it a point to say, listen, you guys are making a difference because you're maxing out the phone lines. Judge Netburn has specifically mentioned the public interest in this case, and it's also listed in the order that Judge Torres did on the granting us amicus standing. Says the same thing. If you look at her order, there's a reference there that it's good to help the court, that we're going to be able to assist the court in understanding the impact that it has on the public interest. You know what I mean? And so I encourage everyone to join. And I think that obviously the other thing for me to say is that it's anonymous. Some XRP holders might provide affidavits. I might ask you guys, Ripple's attorneys might ask you guys as content providers, that this is how you acquire some of your XRP. It's for that consumption use, that non-investment purpose. But you can only do that if you consent to it, right? It's not like the list is going to be provided to the SEC. But I do think some people are worried about retaliation by the government or something.
Right.
But
And here's kind of a final to that point as well. And I know others have asked similar questions around this, but if we win, will we get a payout from the SEC? And does it have anything to do with the amount that they're holding? But the most important part is there a light at the end of the tunnel for victory? What does that exactly mean? What does that win look like for the XRP community? For those that are
right now, we're not seeking like compensatory damages, because if I argued that, we wouldn't even be allowed amicus standing. Right now, we just want the declaration about today's XRP, secondary market XRP. After that is done, then there's another step to go against the SEC thereafter. But in the immediate action with Ripple, it's all about getting the clarity that the XRP we own and that we purchased is not a security. And then down the road, there'll be a different avenue for that.
Right on. Well, gentlemen, I want to thank you from Jeff and I for you guys being here. It's a big thrill to have you guys both here, and also for the XRP community. You missed a lot of the other glowing comments, but what you two do is so appreciated. It's so important. And you guys are famous, man. You guys will go down in history and part of the history books. And I just want to go around. I want to just say last word. Jeremy, you want to give a last word to wrap up your thoughts?
Yeah, me and John have said this before, but I know John and myself were motivated by the XRP community. John's
Something happened to your mic there for a second. It got a little buzzy, maybe. Did you maybe unplug it, perhaps?
How's it now?
But you hearing the static? Yeah, a little static coming in.
All right. Well, we're at the wrap up.
We'll go through it. Come on, we'll go through it. Go ahead. Oh, we lost him. Why did I have to say it, Jeff? Why did you let me interrupt Jeremy? That was so dumb of me. My God, he was on a roll too.
He was on a roll.
Man, he was on a roll.
Okay, I'm back.
Okay, so you deserve to be heard, man. This is important. Let's go.
Yes, I'm back. All right. Well, I really just the thing that I wanted to point out is that we do what we do for free. John spends a lot more time than I do. He really deserves a lot more credit than I do. I really just have fun with the videos. I have a little fun on Twitter, but more fun than I probably should. You're talking to a lawyer that has a unicorn pen.
Oh, that's a pen. Oh, that's a pen.
Big ass pen, man.
So, but it's really the appreciation that keeps us going. But I really want to throw all the credit to John, because he's doing all the heavy lifting. I'm like, he's running the laps and I'm sitting back timing him. That's all I'm doing. So I appreciate you, John, and thanks for guys for having me on. Appreciate that.
Well, I appreciate you saying that, Jeremy. But listen, as I've said to everyone, we all play our role, right? I'm playing my role, but everyone in this community is playing a role, uncovering the videos, whether it's DAI or Backup Bradley or anyone else out there that is finding these clips and finding these videos. We all play our role. And so it's an honor for me to play mine, because as Jeremy said, Jeremy and I, we're not 25 anymore. And when you litigate, as much as we enjoy it, it can be exhausting, and everything's always comes down about arguing over money. And sometimes it can disenfranchise you a little bit from the law. And when you get involved in something like this, a community like the XRP community, it motivates you, and it certainly motivates me. And as much as people appreciate me or Jeremy, I can speak for us both. We appreciate everyone. Trust me.
Jeff,
it's outstanding. Hey, I wanted to give just a quick shout out to everyone that came on tonight, everyone that threw in some support for On the Chain. Want to give a big thank you for both Jeremy Hogan and John Deaton for everything that you guys are doing in the community. And to Jeremy, it's just as important timing the person running as it is running. So, but no, you guys are both outstanding. I want to really thank you both for coming on, and for all of those out there watching us. Just remember, we do stream 6 days a week, Sunday through Thursday at 8 p.m. Eastern Standard Time, and every Saturday morning at 8 a.m. Eastern Standard Time. Over to you, Chip.
Yeah, I would say same thing. But by the way, when you guys talk about that, like, you know, that everybody plays a role, you know, that drone shot when it's flying over a city and you like see a couple people look like ants? That's me waving. I'm like, yo, I'm over here. Hello. But that's just it happens. But everyone does play the role. This is a tight community. I love this. You call them the Twitter sleuths. I think, John, that something along those lines. Guys, keep doing what you're doing. Keep uncovering what you're uncovering. DAI. And of course, Brad Kimes, I mean, doing some amazing stuff. Mr. B, I'll throw him in there as well, doing some stuff. Everybody's playing their part. Thank you, guys. Hang on a little bit. We're just going to spend 1 or 2 minutes with you guys once we go on live here. But guys, Chip, Jeff, Deaton, and Hogan, we are out. See you guys in the next one. Hang around, guys.
The next one. We're out.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.